All right, good afternoon, everyone. Let's go ahead and get started. This is the state expedited accusations calendar in the state court of Fulton County, Georgia. I'm Judge Melanie Williams. And at this calendar today, we will set bonds for those individuals recently arrested and the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right. Is courtroom 2 on the line? I see courtroom 1. There's courtroom 2. All right, all defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel at this proceeding. This particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, that is what I'm referring to. Have all defense attorneys had the opportunity to interview their clients?
No, Your Honor, I need a breakout room for Mr. Esteban.
Interpretation.
Interpretation, yes.
Is the interpreter on the line?
Not as of yet, Judge, but we did request one.
Thank you, Miss Grace. Hopefully she's coming. All right, and is Mr. Esteban the individual at courtroom 1?
No.
No. Okay. Well, if he at courtroom 2, will he be taken over there when interpretation comes?
Yes.
Okay. Are there other announcements at the jail? I know that 15 is a waiver. Are there announcements at the jail or from the public defenders other than that request for waiver and breakout?
We will have 2 separate groups. So this will be the first set, and then I'll bring out the rest of them after these 2 cases are done.
Okay. All right. Who do we have first then?
Courtroom 1, position number 12.
Okay, this is Mr. Reed. Mr. Reed, your case is 24 CR 00570. I'm sorry, 5770G. You're charged with battery. You understand your rights? Can Mr. Reed hear me? All right, great. This is first arrest, so we'll go straight to Miss Allen.
Thank you, Your Honor. This is an incident that occurred at about 2:30 this morning on the 16th. My notes say that he's already got a $3,000 bond. At about 2:30, police were called to 915 West Peachtree Street, Northwest. The defendant reported that he was walking back to his car where it was parked, and he thought someone was breaking into his vehicle. Another stander, like a passerby, said, "Hey, I think that guy just broke into your car." The defendant approached his car and saw the window was broken. His car was on 8th Street there. His car alarm also had just gone off. He saw that his window was broken, and he reported to police that he tried to make contact with the person who'd just broken his window. He tried to detain that person, but the person put up a fight. The defendant said he pulled his firearm out and he pistol whipped the young man. This caused a gash in the head of this gentleman, requiring stitches. His name is Leon April. And Mr. April was also arrested, Your Honor. So he was transferred after receiving treatment at Grady. Mr. April did report that he was fleeing. He denied that he engaged in a physical altercation with the defendant. And this is his first arrest. So we would agree with what he already has, a $3,000 bond. We would request that it be surety, no contact at all with Mr. Leon April, no drugs, alcohol, or weapons, surrender any firearms, and complete a firearms safety class, Your Honor.
Okay.
Thank you.
Thank you, Ms. Allen. Ms. Kim, is this your client?
Yes, Your Honor.
In light of the information before me, I'm inclined to give your client signature bond through pretrial, but require the surrender of that weapon. Any objections, Ms. Kim?
No objection, Your Honor.
All right, we're going to convert the 3,000 surety to a 3,000 signature. He is to surrender any firearms, have no alcohol, drugs, or weapons. That signature bond will be at level 1. He is further to have no contact whatsoever with Mr. April. All right, Mr. Reed, best of luck to you. That concludes your case.
Who is he surrendering the gun
He
to?
needs, it's supposed to be local law enforcement, correct? That's the email I got. And not pretrial. He does
Yeah, I
not
know,
surrender.
but I know last week we had a case and they was like, who they supposed to surrender to?
Sheriff's
I didn't know.
office,
The
the sheriff's
sheriff.
office.
Yeah, y'all might want, yeah, but that's I put on the bond order, I guess, just so they'll know.
Yeah, don't bring it to pretrial. All right, who do
We
you
ain't
have
taking.
next?
Position number 7, Ms. Harden.
Okay, Ms. Harding, your case is 24 CR 005760F. You're charged with disrupting a public school. You understand your rights?
Yes.
All right, thank you. First arrest. So again, Ms. Desiano, please proceed.
Good afternoon, Your Honor. This incident took place December 4th of last year at the Cascade Elementary School. The school resource officer reported that at approximately 8:10 a.m., the defendant, who was a teacher at the time of this incident, intentionally dispensed an unknown white powdery substance on the floor around the hallways in front of the school principal's office. The principal in this case, her name is Tiffany Moman. She made contact with the substance and immediately began to have a reaction of some kind. And so when that happened, 911 was notified, the hazmat team was dispensed, Homeland Security was put on standby, the FBI was also put on standby, the school was put on lockdown, all activities were suspended. The defendant was caught on video spreading the substance. We have been in touch with the principal today. She states that at this point, they still don't know what the substance is. It's my understanding that on scene, there was a test done. I believe they've ruled out like anthrax, but they still don't know what the substance is. And I don't have any information about whether that substance is being tested at this point, but we have requested the evidence. She states that she does not understand why the defendant would do this. She said that she had to discipline the defendant in the past, but that was a bit prior to the incident that happened. So she feels like it was out of the blue. She stated that her blood pressure went up and it would not come down, and she had difficulty breathing. She states that she did file for a TPO after this incident, and that TPO was granted and is active until January of next year. This defendant was fired after this incident and is not allowed back on school property. Your Honor, the state's concern obviously is that this is with the reaction that the one person that came in contact with this substance had. This was a school full of children and incredibly dangerous. I think this defendant is a danger to the community. I'm glad that she's not allowed back at that school. The state at this point is requesting a $5,000 surety bond, a stay away from all schools, no further contact with Ms. Moman, no weapons, drugs, or alcohol. And I'm also going to request a BHET. I'm not sure if Ms. Moman's on the line, if the court can sound for her. Thank you.
All right, because the charge is disrupting public school, I'm not going to sound for Ms. Moman at this time.
Okay.
Who represents this defendant? Mr.
I do, Your
McClain?
Honor.
I'm inclined
Yes.
to give your client a signature bond through pretrial per judge. Any objection to that?
No objection.
All right, defendant's going to receive a $4,000 signature bond through pretrial services at level 1. She is to have absolutely no contact with Ms. Moman whatsoever and stay away from all schools unless she's employed at one. She is to have no alcohol, drugs, or weapons as a condition of that signature bond through pretrial. Is there anything additional?
Nothing.
Nothing from the state.
All right, best of luck to Ms. Harden. Who do we have next?
Excuse me, Judge, was that a no further contact or just a stay away?
Both. Stay away
Okay.
from all schools and no further contact with Ms. Moman.
We can go to ACDC.
Has ACDC heard their rights?
No, Your Honor.
You said yes?
No.
They have not. Okay. All defendants at ACDC, please pay attention. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney today, and I'm conducting this hearing by video. Who do we have first at ACDC?
Good afternoon, Your Honor.
Good
Petition
afternoon.
number 1, Ms. Atkins, come up here and have a seat.
Okay. I'm not going to sound this charge, Ms. Atkins. Ms. Atkins, your case is 24 CR 005756J. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Howard.
Third, 2021 robbery, false imprisonment, first offender, probation. 2021 afraid.
Okay. All right, Ms. Esiano, I caution you that I know you're gonna want to give me the substance of the case, but let's keep in mind the sensitive nature of what we are discussing here. All right, please proceed.
Certainly, Judge, I'll be discreet. Essentially, this was an investigation for an ad that was on the internet. An undercover officer made an inquiry, and the officer ended up at the Days Inn at 505 Best Road and made contact with the defendant. The reservation of the hotel room was also in the defendant's name, and while the officer was there, he called the phone number that he'd been interacting with and having text conversations with, and the phone was in the defendant's hand and ringing. Your Honor, the freight case that she has was upgraded to a battery, and it's currently open. That's 21 CR 5868, and it's in failure to appear status at this point from a failure to appear from March 1st of this year. That's in Orca. In light of that, I would request a $1,000 good bond, a stay away from the Days Inn, and no weapons, drugs, or alcohol while on bond. Thank you.
All right, Mr. McLean.
Oh,
Is
that's
it-
somebody else.
This is my
Oh, it's
case,
not
Your
you.
Honor.
It's
I'm
yours,
sorry.
Mr. Cook.
Yes,
You
ma'am.
got me thrown off, Mr. McLean, because you're not muted. Please proceed, Mr. Cook.
Yes, Your Honor. My client is 27 years old and has lived in the area her whole life. Up until recently, very recently, she was homeless. She's not employed, but she has 4 children, 2 of which live with her. She's not in a position to make any kind of money bond, and we would be seeking a signature bond at whatever level the court deems appropriate.
All right, defendant's gonna receive a $5,000 signature bond through the jail. She stay away from that Days Inn and have no alcohol, drugs, or weapons as a condition. Is there anything additional?
Nothing from the state, Your Honor.
Nothing
All
else.
All right, best of luck to you, Ms. Atkins. Who do we have next?
Can we get, the Spanish interpreter, in the breakout?
Okay, yes, who's here today? Is it you, Lucia? Or is it you, Adriana? Who's here for interpretation today?
It was supposed to be Lucia, but
I see it just says certified.
Yes, Your Honor. Yes.
All right, can you raise your right hand, please? Do you swear and affirm that today you will make an accurate translation from English to Spanish, Spanish to English, to the best of your skills, your knowledge, and your abilities?
I do.
All right, can we put Mr. Cook into the breakout with Lucia, please? And is it courtroom 2 or courtroom 1?
Courtroom 1.
Okay. All right, and we'll continue with ACDC. Who's next?
Your Honor,
They should not-
Quorum 2 has not heard their rights, and we can do one at Quorum 2.
Okay, so we're not going to ACDC?
We could jump back and forth between.
Okay. All right, so who's coming at courtroom 2 then?
They haven't heard their rights.
Okay, but you don't want to call somebody up and I'll do it so we can keep moving?
Position number 11, Mr. Mon.
All right, thank you. All right, good afternoon, everyone at courtroom 2. Please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. As you can see, I'm conducting this hearing by video. If I ask you if you understand your rights, that is the rights to which I am referring. Ms. Grace, what's my reset date? I forgot to ask that. Ms. Grace?
Sorry, Judge,
That's
August
okay.
the 29th.
All right, those who receive a surety bond will be reset to state all purpose on the 29th, where we can revisit aspects of your case. Those who receive a signature bond, whether through pretrial or the jail, will be reset further notice. Mr. Monaghan, your case is 24 CR 005762J. You're charged with reckless conduct. You understand, right?
Yes.
All right, Mr. Howard.
Who is this?
11 Monaghan.
11 total. 2020 suspended license DUI. His history is just mostly driving and drugs.
Okay, that's okay. All right, Ms. Allen, please proceed.
Thank you, Your Honor. This is an incident that occurred yesterday on the 15th of August at about 4 p.m. This is in the Walmart parking lot at MLK Junior Drive. That's 835 MLK. Police were on the location scene and were flagged over by someone who pointed out that there was a vehicle that was off with the windows up, and a child crouched down behind the passenger seat in the floorboard, alone in that car. It was well over 80 degrees yesterday. Police made contact with the little girl who was an 8-year-old, initials HM, and she was spoken to in an effort to help her unlock the doors of the car. She was unable to do that. Eventually, police made contact with the defendant, who is her father, and he was charged with reckless conduct. So the reckless conduct would be based on leaving a child with the windows up, the car locked, and not on, outside, alone and unattended. And the fact that the child was on the floor behind the passenger seat on the floorboard indicates to the state that she knew that that was probably not a great thing, and that she didn't want to draw the attention of police. This gentleman has multiple felony convictions for felony drugs and possession of firearms, Your Honor. The last one being 2018, I believe. We're asking for a $2,000 surety bond, no unsupervised contact with this child. I'm not sure if this child is a product of a marriage or someone that he shares custody with, or if he's got legal rights to the child at this point, but we would ask for either no contact or no unsupervised contact, and no drugs, alcohol, or weapons while on bond. Thank you.
All right, thank you, Ms. Allen. Who represents this defendant? Is it Mr. Cook? I
No,
hope
it's-
not.
It's Kim.
Ms. Kim, this is your client?
No, actually, I am actually on the phone with my client at ACDC. I'm just trying to interview. Who are we doing now?
This was Mr. Monaghan.
Yes, ma'am. Yes, ma'am. Hold on, please, Your Honor. Yes, I do have a Mr.
Ms. Allen asked
as
for a
well.
$2,000 good bond. I just have a question. The child at issue in this case, that is his child?
Yes, 1 year old. I mean, one child, I believe so. They do not live together. He does not pay any child support. Yes, he's 13 years old.
Okay, so the child at issue in this case is not his child.
You know what? I made a mistake. He was 8 years old, and it is his child right now. Child's mother is having a child, and defects is not involved yet.
Okay. And
I guess I'm confused. So we've got an 8-year-old little girl, and the defendant was taking care of her because mom's having a baby?
No. His mother is having that 8-year-old child because he is arrested. He just went into get something to drink and it came out, and yeah, he said it was only 3 minutes.
So the child lives with him?
No, he does not live with him.
Child does not live with him?
No.
And he doesn't have a supervisor, like there's no order yet for visitation or child support or anything of that nature?
No.
Okay.
And I did a search in case manager, Your Honor, for any filings related to legitimation or divorce or anything, and I don't see anything like that, and no child support out of Fulton County either.
Okay, so what we're gonna do is the defendant's gonna get a $2,000. Okay, well, let me ask this. Ms. Kim, do you object to a signature bond through pretrial at level 1? But what I am gonna do is restrict him from visiting that child for now, but we can revisit that at a later date, okay?
Yes.
Do you have any
No
objection to
objection.
that?
No.
Okay.
No objection.
All right, defendant's gonna receive a $2,000 signature bond at level 1 through pretrial services. If it needs to be per judge, it's per judge. He is to have no contact with that child for now. Of course, contact can be revisited at a later date. Additionally, he's to have no drugs, no alcohol, no weapons as a condition. Is there anything additional?
Nothing further from defense, Your Honor.
All right, best of luck to you, Mr. Monaghan. That concludes your case. All right, are we going back?
Judge, Mr. Howard, does it need to be per judge or not?
Say that again?
For position number 11, she said if it needs to be per judge.
Oh, nah, you don't have to.
Thank you.
All right, who we have next?
Position number 6, Ms. Jeter.
All right, good afternoon, Ms. Jeter. Your case is 24 CR 5757D. You're charged with disorderly conduct. You understand your rights? Is that a yes? All right. It's first arrest, so we're gonna go to Ms. Desiano.
Your Honor, this incident took place on August 14th of this year. Officers were dispatched to 3561 Potomac Terrace in East Point. The victim in this case is Vanessa Jeter. She's the defendant's mother. She stated that she and the defendant were arguing over a cell phone. The defendant got very angry because she wanted the phone and started throwing things all over the house. She knocked over a plant. She knocked over some chairs. She messed up her bedroom, the bathroom, etc. At one point, the parties were also physically tussling over the cell phone. The defendant fled the scene prior to police arrival, but was found circling the block in her vehicle. And the police eventually made contact with her and arrested her. Your Honor, we have been in touch with her mother today. She states that, sorry, there's a lot here. I've said most of it. She states that there was an issue over the cell phone is initially what started it. They were tussling back and forth. She states that when the defendant gets angry, she throws things and destroys property. She says that she wants the defendant to get some kind of help. However, she's not in fear of her and would like to continue contact, and she was okay with the defendant returning to the residence. Your Honor, the state's requesting a signature bond through pretrial, no further violent contact with Ms. Jeter, anger awareness course, a BHET, and no weapons, drugs, or alcohol while out on bond. And I believe Ms. Jeter's on the line.
All right, Ms. Jeter, if you wish to make a very brief statement, please raise your right hand and unmute your screen so I can place you under oath. Your screen is still muted. We can't hear you.
Can you hear me now?
All right, yes, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. What I am most concerned with today is whether you wish to have contact with the defendant and any concerns or fears you have for your safety. If you disagree with something Ms. Desiano said, that's not what I'm most concerned with, because I'm not sentencing the defendant today. This is just a bond hearing, and there's more work to do at a later date. So what would you like to tell me, Ms. Jeter, in light of those instructions?
I just feel like my daughter needs some mental health help. She's been in and out of behavioral health facilities, and she cuts herself. She needs help. I'm not afraid of her, and I'm not feeling like I'm in danger of her, but I just feel like she needs some mental health help, court ordered, so she'll go so she can get better.
All right. I appreciate you coming to court making that statement. Ms. McLeod, this is your client?
It is, Your Honor. Good afternoon.
Good afternoon. I'm inclined to give your client the signature bond through pretrial with the no further violent contact provision, and to require a one-day anger awareness course. Is there any objection to that?
No objection, Your Honor.
All right, defendant is going to receive a $5,000 signature bond through pretrial services at level 1. She's to have no further violent contact with her mother, the defendant, the alleged victim, last name Jeter. She's going to take the one-day anger awareness course, have no alcohol, drugs, or weapons. All right, best of luck to all parties.
Thank you, Your Honor. That concludes my business before the court today. May I be?
Thank you.
All right, you have to leave us, Ms. McLeod. Does anyone else need a conflict before Ms. McLeod leaves? Everybody else is taken care of. All right, take care, Ms. McLeod. Have a great weekend. See you soon.
Thank you. You too.
All right, can we take the interpretation? Oh, we really can't take the interpretation case. It's gonna have to be last. I'm sorry. We're gonna try to move things along. Okay. All right, who do we have next?
We can go to position number 2, Mrs. Dunn. You can go. Yep.
Good afternoon. Your case is 24 CR 005758Y. You're charged with criminal trespass and simple battery. Do you understand your rights?
I do.
All right, Mr. Howard.
6/2024 FTA. Open shoplifting FTA out of the cab. And open shoplifting out of the city of Atlanta. That's all.
Shoplifting. Okay. All right, Ms. Desiano.
Your Honor, this incident took place August 15th of this year. The security officer at the Hugh Midtown Apartments at 22 14th Street called the police regarding a criminal trespass. A couple months ago, this defendant was evicted from an apartment at that location, And she returned to the property on August 11th, which was about 5 days ago, and was issued a criminal trespass warning and told not to return. She returned to the property yesterday, however, demanding to be let into the apartment that she was evicted from. When the officer arrested her and attempted to get her out of his patrol vehicle, when he arrived at the jail, she kicked him in the knee. Given her open cases, Your Honor, the state's requesting a $2,000 good bond, $500 on the criminal trespass, and $1,500 on the simple battery against law enforcement, a stay away from the Hugh Midtown, no further violent contact with law enforcement, no weapons, drugs, or alcohol while out on bond. Thank you.
All right, thank you, Ms. Sessiano. Who represents this defendant?
Mr. Cook.
Mr. Cook, please proceed.
Yes, thank you. My client is 35 years old. She's lived here her entire life. She's currently going to school full-time at Clayton State. She denies the allegations as stated in the warrant, particularly regarding the battery. She believes there was some confusion on the trespass, as she was told she could come back and pick up some belongings from concierge and the leasing officer at the time. So that's why she was there. Beyond that, Your Honor, we would ask for a signature bond at the appropriate level. And
Right.
we have no problem with a stay away or no further contact.
All right, defendant's gonna receive a split bond. It's gonna be a $2,000 total bond, 1,000 signature through the jail for the trespass, 1,000 surety for the simple battery. She is to stay away from that location. She is to have no alcohol, drugs, or weapons, and no further violent contact with that officer. Because of the split bond, she's going to the all-purpose calendar. I believe it was the 23rd. Is there anything additional?
Nothing from the state.
I'm sorry, 29th. She's going to all-purpose on 29th. All right. Best of luck to you. That concludes your case. Who do we have next?
We can go to position number 5, Mrs. Frederick.
Your Honor, I'm sorry to interrupt. This is the interpreter. I do have a little bit of a time constraint. I'm only available until 2:45, 2:50 at the latest. If not, I can come back in because I'm needed somewhere else at 3 o'clock. So I can come back after that is over, if that would help.
I'm thinking.
Your Honor, I can be very discreet with the facts.
Okay. All right, we're gonna go ahead and take the interpretation case.
Thank you.
All right, can we turn off the live stream, please?